from supplementary list. Item number 1.
Please, Your Lordship. Lordship, this is a criminal writ petition, my lord. We're challenging the order passed by the General Security Force Court of the BSF. Whereby, my lord, of the BSF, General Security Force Court under the BSF, my lord. Similar to the court martial. Whereby, my lord, the petitioner has been convicted for life under 302 of the RPC, my lord, which was the similar to IPC in Kashmir. And also, my lord, the order passed by the appellate authority, which is the Director General. This is the third round of litigation, my lord.
Take notice. I'll file an affidavit. He also killed his fellow colleague, my lord. He also killed his fellow colleague.
302.
Oh, killed. Oh, that's why 302. Yes. With a rifle, my lord.
9mm.
Huh?
The carbine rifle pistol.
What is it you want us to do?
No, lordship, I'll satisfy, my lord. This is the third time we are coming here. 2 times the order has been interfered with.
Yes. Notice.
Obliged, lordship.
Submit notice. Obliged. July.
Obliged.
Yes.
Item number 2.
But this is regarding promotion, my lord. We have come against the order passed by the Central Administrative Tribunal, but the notice has to go, my lord, to the respondent. Really, but is there any earlier round of litigation to the? It's the first time it's coming today. First round. But saw some orders of the Supreme Court. What is the order at page number 54? My lord, this is the decision they are relying on, my lord. Admit notice. 2 months. 2 months. 2 months. Yes. Did.
Item number 3.
Customs of
Please, Lordship. The arguing counsel, Mr. M. Dasgupta, is not available, Lordship. Therefore, I pray that the matter may be adjourned for the day.
It's a case of seizure of gold, my lord. Seizure of gold, my lord. More than 4 kg of gold, man. 4 kg of gold. 4 kg. Yes, at the request of the appellant. What's the matter? When do you want?
After a week, Lordship.
$14, $15, $16 CD, some date.
From the daily list. Item number 1.
May it please your Lordship. Lordship, this is the second round of litigation. The petitioner has had earlier also filed a PIL before this honorable court with regard to the way bridges. And that was disposed of in 2023. The order is at page 61. If I may take your Lordship to the order. Page number 62 is the relevant portion. Paragraph 3. In addition, the Transport Department has placed orders for 6 weigh pads, out of which 2 have been received. One of the weighing pads has been installed at Dalu and the other is being installed at Umtenga in Ribhoi. It is hoped that the remaining 4 weigh pads are installed within the next 6 weeks.
Yes.
But, my lord, in Dalu, the present condition is this particular statement was made that weighing pad has already been installed in Dalu. but the petitioner himself visited the spot, and we have annexed the photographs at the Dalu place. If I may take your lordships to page number 85. Page number 85, which shows that the integrated smart check gate is that way, the blue board. And if we go that way, at page 86 is the location. There is no weighing pad at Dalu, my lord. And trucks are going unchecked. Overloaded trucks are passing through the border also towards Bangladesh. So there is no check on what the compliance of section 113 and 114 of MV Act is not at all being followed by the state. After the order was passed by this honorable court in the previous round of litigation, the petitioner has
My lord, I will require instruction. Excuse me.
keep your obliged.
Obliged.
Item number 2.
Lordship, in terms of the last order, Lordship, in terms of the last order, Lordship, status reports was supposed to be filed by the learned TSGI, Lordship, in respect of package 1, 2, and 4, Lordship. 1, Lordship, status report was supposed to be filed by the learned DSGI, Lordship. This is that matter pertaining to the widening of the road, Lordship.
No, you're not able to follow. Oh. Oh, yes, yes. Status report regard progress with regard to package 1, 2, and 4.
Lordship. But I'm paying for some time, madam. Couldn't file the affidavit.
The request of Dr. Moshika. What's the matter? What do you want?
15, 16.
15th or 16th?
Lordship, the state also will file within a week. We have just got the instruction. We'll bring on record on affidavit.
You file it.
Lordship. No, we have not filed. We just got instruction. We'll bring on record through affidavit within a week. Within a week.
So filing status report.
Okay, चल रहा है। Okay, चल रहा है।
Item number 5.
आज का पेपर में क्या?
May it please your lordship.
Yes, sir.
Lordship, I am appearing for the sole respondent, and I have filed my objection. So may I pray that a date may be fixed, your lordship, so that the hearing can be over.
What do you say?
My
Not
lord,
audible, sir.
my lord, my friend is submitting that we have already filed our objection.
Yes.
So, my lord, as on the last occasion, I filed objection, but I've been informed by
We
my
have
friend we
received
wanted to file a rejoinder.
We have received the objection, Lordship.
An objection affidavit opposing so on. So yes, it is there.
My lord, on behalf of the sole respondent, my lord.
I think this is the matter I heard,
Lordship.
last time.
Lordship. With regard to the objection, Lordship, I pray that some time may be given to obtain instructions from the department, Lordship.
At the request of the department, counsel for appearing with the department, what's the matter? After 2 weeks.
Deeply obliged, Lordship.
Obliged, lordship.
Item number 6.
This is an ITO, 24 matter, you posted it for 1 month.
Lordship, this is a commercial appeal matter with a miscellaneous case for condemnation of delay. 4 days only, Lordship. The last occasion on 20,
4 days delay.
only, Lordship was pleased to opine that since the other side is absent, otherwise it would have been considered. But my friend has appeared today.
Yes.
Lordship, we received the date on a very late basis because of which we were not able to appear. The senior counsel would like to argue the matter is busy today.
That is right. With regard to delay. With regard to delay.
With regards to delay application,
4 days delay you are opposing.
he wants to argue the matter, Your Lordship. Just give us a very short day, please, Your Lordship.
Where it will decide.
Yes, Your Lordship.
With regard to delay, we will condone the delay. Respondent, I have no objection for delay being condoned. 4 days delay is condoned. Registry is directed to number the main matter and list it for hearing. Next week. What is the issue?
Lordship, we come from Guwahati and we have a lot of money. If I may suggest few dates from 27th to 30th of this month for the next date of hearing.
You want between 27th and 30th.
Yes, Your Lordship.
For the request of the counsel for the respondent, pose the matter on 27th.
Please, Your Lordship.
Lordship, I beg to submit one small matter, Lordship. On the last 28th, I moved the matter, but in the course of appeal, my name has not appeared. Of course, it appeared my junior's name. It should be kindly be allowed with R. Chaudhary, not N.I. Chaudhary, Lordship.
What is it?
on the last motion date, on 28th, my name has wrongly been, has appeared as N.I. Chaudhary. I am R. Chaudhary, Lordship. If it is allowed to be corrected.
Your name is Wakalatnama.
Yes, yes. N.I. Chaudhary is my junior also, but I moved the matter.
Yes.
Because it is a corporation matter, so in the matter of
verify
other,
the Wakalatnama and print the correct name in the cost list.
much obliged.
Much obliged.
Post on the request of the respondent, post the matter on 27th.
The signature Sangma. Come. Come.
From supplementary list, item number 1.
Lordship, may I please the Lordship? Lordship, this is an appeal against the order passed by the learned single judge, Lordship. Like, Lordship, today the application for condonation of delay has been listed, Lordship. There is a delay in filing the appeal, Lordship.
600 days delay.
Lordship.
What is the justification?
Lordship, here, Lordship, what has happened is, Lordship, after the passing of the impugned judgment by the learned single judge, Lordship, we have approached the learned single judge by a review petition, Lordship, and that came to be disposed in, Lordship, 8/2/2024, Lordship.
8/2/2024,
Lordship.
8/2/2024.
Lordship.
Review.
Lordship. And
then you file it in April.
Lordship. Thereafter, Lordship.
Where have you stated?
At para 2, Your Lordship.
Lordship, para 2.
There are two.
Para 2, Lordship.
Do you have any objection?
Yes, Your Lordship. Your Lordship, this 621 days of delay, Your Lordship, from a bare reading of this application for condemnation, it appears that it has suffered from a lot of laches and negligence on the part of the writ appellant, Your Lordship. Because immediately after filing or passing of the judgment by the single judge, Your Lordship, they have filed a review petition, which they left to be just like that for a period of 2 years, Your Lordship, and then they withdrew it, Your Lordship.
Withdrew
the petition.
the review application.
Yes, the review petition was withdrawn by them after 2 years. And then they have filed this appeal, Your Lordship. And besides that, Your Lordship, there are other respondents who may be interested to also object in this.
Not private respondent and the managing committee.
This appeal is not representing the he is not representing the individual. Here he is representing his
Correct.
But the object of 7. It is an individual. Ideas
What is your locus standi in filing this appeal?
I am the head teacher in the scholarship.
Your rank 7.
Lordship.
Yes.
Respondent 7.
Lordship.
In the writ petition.
Lordship.
See respondent 7, page number 27.
Yes, Lordship.
So and so school represented by so and so the secretary come headmaster.
The head teacher is the secretary.
See the present appellant.
She is not in the capacity of the secretary of the managing committee. She's done it in a personal
Here if you
capacity.
condone the delay, we'll have to dismiss it.
Lordship, secretary and ex officio member and convener is the same post now, my lord. Is the same post. Ex officio member and convener is the same post equivalent to the secretary, my lord. It has been, the nomenclature has been changed, my lord. Now,
Where have you stated?
Not stated.
Where have you stated? See, suppose you say that the post of secretary and headmaster has been abolished, and that person can be represented by, you must file a petition to accept the cost title, and thereafter prefer an appeal. Suppose a person dies, a respondent dies, and he is entitled to monetary benefits. Naturally, legal heirs can represent by filing an appeal. But legal heirs will have to get substituted in the place of deceased and thereafter contest. No, you know, no pleading at all. On that ground, see, we don't agree with her submission. Legal proceeding, those proceedings period can be excluded.
Lordship.
There is a judgment of the Supreme Court and that arose from Madras High Court. CP Saradi was the State Bank of India. And the matter is pending before the court, the period will have to be excluded. The provision is also there in the Limitation Act. It is different. But insofar as appeal is concerned, it's not maintainable. What is it?
What I wanted to find that here this is here's this person cannot be saying so is not
Lordship, in that event, Lordship may allow 1 week's time, Lordship. I'll have instructions taken and Lordship, I'll come before Lordship.
Not required. We'll condone the delay and dismiss the appeal.
Lordship may kindly have this matter next week, Lordship.
Not required, sir. Not required.
I'm, Lordship, Mr. Paul is leading in this matter, Lordship. Therefore, Lordship,
Whoever it is.
Lordship.
See, we are concerned about the black and white before us. That's all. Nothing else.
Lordship may have it on Monday, Lordship. Then, Lordship, I'll have instructions taken,
Sorry.
Lordship.
The present application has been filed. We condone the delay of so many days. The main contention of the appellant is that against the order of the learned single judge, review petition was filed and that the review petition got disposed of in the month of February 2024, 8/2/2024, and that the appeal has been preferred in the month of April 2024. For the purpose of counting the delay, the date of passing off the original order is taken into account, and the total number of delay as 600 and odd has been mentioned. The council submitted that the delay, if any, would be less than 60 days, and that the pendency of the matter, review petition, pendency of the review petition needs to be taken into account, and that period has got to be excluded for the purpose of condoning the delay. See, we have passed orders. We have one 1969 judgment which we have taken to the respondent vehemently opposed condoning the delay on the ground that after filing the review petition, the review was withdrawn as dismissed, was dismissed as withdrawn. As there is exorbitant delay, this court will have to reject the application on the ground of laches. Both parties. We are satisfied with the contention of the petitioner. The period during which the review petition was filed, was pending, need to be excluded for the purpose of condoning the delay. Though in the affidavit it has been stated that there is a delay of 600 days, the delay is only less than 60 days. And that reason given by the petitioner Germain and we do not agree with the contention of the respondent in condoning the delay. We do not agree with the contention of the respondent that the delay should not be condoned. Having satisfied with the reasons given by the petitioner and the submissions, we condone the delay. The registry is directed to number the appeal. Supplement list, you put the supplement list. Agreed by the order of the learned single judge, dated so and so. The present appellant has preferred the appeal. The seventh respondent in the writ petition is agreed by the order, and the appeal has been preferred in the personal capacity as ex officio member and convener of the school. Full stop. Though it has been stated by the petition appellant that the present appellant is empowered to file the appeal in the ex officio, in the capacity of ex officio member and convener, we are not inclined to accept the same. Full stop. When the post of secretary or headmaster exists, the school having been represented by the secretary and headmaster, the appeal has got to be filed only by the said person. In case no such post exists and that ex officio member and chairman is empowered to file an appeal, the appellant should have filed an application seeking amendment of cause title and the permission of this court to prefer an appeal. Stop. As the appellant has approached this court in an individual capacity and that the seventh respondent in the writ petition is not before this court by way of an appeal, we are not inclined to accept the contention of the appellant and dismissed on the ground that the appellant has no legal capacity to file the appeal. Dismissed.
Liberty may be granted, my lord, for appropriate appeal to be filed, my lord.
Sir?
The liberty may be lordship
Why
granted.
should we give liberty? It is entitled to file. There also there will be delay. There will be delay of more than 600 or 700 days.
Lordship.
That we may condone, we may not condone.
Obligation.
Hello.
Item number 2.
CBI.
Yes, my lord. My lord, this is an application by
So what
CPI.
happened to you yesterday? Sorry. What happened to you yesterday?
My lord, I
Sitting, no?
my lord, I apologize, my lord, that.
But you're posted here. Be here.
Today I'll be there, my lord.
Yes.
My lord, this is by CBI, my lord. We are asking for extension of time to complete the investigation, my lord.
Extension of time?
To complete the investigation.
Investigation.
Yes, lord. My lord, lordship kindly turns to page 41, my lord.
Page 41. Yes.
This is the order, and in para 22, my lord, your lordships have directed at page 50, my lord.
Para number, sir?
Para 22 is page 50, my lord.
According to the typical also, investigating
Well, preferably within 6 months' time was given, my lord. Now, my lord, we have started the investigation, my lord, and your lordship kindly turns to page 8, my lord, at para 26. You have stated, my lord, that in order to bring the investigation to its logical conclusion, Central Bureau of Investigation requires extra time to conduct crucial exercises.
When was it started?
My lord, this was started pursuant to the order of the learned single judge, my lord. That your lordship will find at page 11, my lord. But this was a case of encounter death, my lord.
Page 11.
Page 11, my lord.
How many months you require?
6 more months.
6 months.
Because many forensic investigations are required, my lord. I have stated in para 26, my lord, at page 8.
To give we must know the progress. Suppose you come once again and seek for another 6 months time.
No, my lord, here I have stated the progress also, my lord. If I may take your lordship to para 17, my lord.
17
of the application, my lord.
Affidavit.
Of the application, page 6, my lord. Page 6. Same application, my lord. Para 17. That a total of 33 witnesses have been examined by CBI during investigation of the case. These witnesses include complainants, family members.
How many witnesses you examined?
33 already examined, my lord.
Already
my lord. 33.
Been examined, yes.
Now, para 18, you have stated, my lord, that during investigation by CBI, the relevant records and exhibits such as weapons seized by the police from the place of occurrence, mobile phone of the deceased, empty bullet cases, GNLA demand notes.
Well, present application has been filed seeking extension of time to complete the investigation. Mr. Dr. Mosika, appearing to the CBI, submitted that 33 witnesses have been examined after the orders of this court. Apart from seizing relevant records and exhibits. Full stop. As the investigation may take some more time to be completed, he requested further time of 6 months. Full stop. We'll give 4 months time.
Witnesses have already been examined, my lord. Witnesses have already been examined. Only the forensic will take some time, my lord, because this incident is very old, my lord.
That's right. How many do you want to say that you require 6 months?
So, my lord, but we might have to, if also grant 6 months, possibly will not come back. I leave it to you, lordship, my lord.
That's right. 6 months time from today.
English.
From the daily list, item number 1.
Dr. Mosika has appeared in this matter, huh? Before the single judge.
The state is a formal party, Your Lordship. Respondent number 1.
Judgment dated passed and dated number also 57. This is impugned order.
Lord, in this matter, Lord, I'm praying for some time, Lord.
What time?
Lord, on account of the senior counsel's non-availability today, my Lord, the Paul is slightly, my Lord.
What is the matter about?
Lord, this matter, my Lord, there's a challenge made to the order of the learned single judge, my Lord.
What else?
This matter concerns, my Lord, the appointment of Mintri under this Milliam CMship, my Lord, under the District Council rules and regulation.
The 2007 Act appointment.
Yes, ma'am.
My lord, here basically what happened, my lord, District Council passed a law, my lord. Now by executive order, they have repealed the law, my lord, certain provision of law. So against that, we came before this honorable court that this was a legislative action, so it has to be repealed or amended by a law passed by the district council. Cannot be done by an executive order. Ma'am.
Oh, in this case, they have done it by means of an executive order. So what is this? How can it be done? See, how can a legislative power be taken away by means of an executive orders?
My lord, in this case, my lord, even our appointment was made by way of a legislative act, my lord. And my lord, subsequently, my lord, that was also undone by way of an executive instruction.
But the district council is here, my lord. They'll justify their action.
In fact, the Honorable Single Judge was pleased to direct the Khasels Autonomous District Council to sit and look into this matter, and consequent to the direction of the Single Judge, we have heard both parties, and much time have gone in this matter.
By means of a legislative act, it can be done. Why do you want an executive order?
But today I'm slightly handicapped, my lord. If your lordship allows, my lord, we can, I'm praying, my lord, if this matter could be fixed on Monday, my lord.
To grant orders, very simple thing. How can a statute,
it is not
how can a statute be amended by means of an executive order?
I recall.
That is all.
My lord, there are
Can be recalled.
But there are other issues involved, my lord. I'm not being in a position to place it before your lordship today, my lord. That's why I say, my lord, I'm slightly handicapped. If this matter could be fixed on Monday, my lord.
The request post matter. How was it done? 13. 14. 14. It's the only issue, nothing else.
No.
Very limited. See, keeping this matter pending, and there is definitely there will be no progress. Instead of that, a legislative act can be done. That's all.
My lord, if I...
Yes.
Item number 2.
Pleasure.
Your Lordship, in this matter, I'm praying for some accommodation, Your Lordship. We are praying for some accommodation.
Right.
Your Lordship, we have gone through the compilation filed by the appellant. However, Your Lordship, there are some action rules which are missing. So we would want to compile the same and produce before this.
I think this is a case where AJ argued and written submissions, notice submissions.
Written submission has also been filed, my lord, in this matter, my lord.
We want
So
to
by
compile.
taking time, you want us to forget what he has argued. Yes, when do you want?
2 weeks, Your Lordship.
Who's after 2 weeks?
Item number 3.
Obliged.
Much obliged.
Lord, this is that matter, my lord, where we have challenged, my lord, the pensionary rights of the teachers engaged in the aided schools.
This is
are an issue, my lord.
I think similar matter went up to Supreme Court. That is the case.
I'm not sure, my lord.
This is not the case.
This is not the case.
That was
With regard
pertaining
to
to
the
college
pension.
teachers.
With regard to the pension.
No, that was pertaining to the college teachers.
Lord, we just have to examine, my lord, whether that will have a bearing in this case or not.
No, that cannot have a bearing in this case. That's a total different matter.
When do you want?
My lord, may kindly have it next week, my lord. It's a
Yes. The request post. 24. No. 24 we'll see. Yes.
Obliged.
Obliged, my lord.
Once. Yes.
From supplementary list, item number 1.
Lord, this is a motor accident claim.
1 minute.
Very old
This is a
claim.
brief so on to is it along with the original case number so on to the is that see it is the judge has already appeared in the matter, so she wanted to recuse and matter has got to
Not the judge, her husband. Is it?
The husband of the judgment. The husband of the judge was a counsel at one point
At one point of time,
in the past,
he had only signed the wakalatnama. It's not.
never really participated in the matter.
No, it says on the peripheral regime, it appears that Remboy, judge, has recused herself from this case on the ground that she is related to M. Ripnar and once a counsel for the complainant may not be proper for the court to take up the.
Yes, my lord. So Mr. Ripnar was the counsel at one point who is Honorable Judge's husband. Mr. Ripnar is also part of the registry of this Honorable High Court as on date, my lord. So because of that ground, learned judge recused himself. On that
We'll transfer it to some other.
we can do that. We can do that.
Where?
It can be sent to Vivoy.
The nearest logistically would be Nongpo, Vivoy district, my lord. But also, my lord, if lordship allows, if I can make a very humble suggestion to this honorable court for lordship's consideration and my friend's consideration. Lordship, I am prepared to, besides this aspect,
we have no doubts about the integrity or the fair-mindedness of this particular judge, my lord. So I am prepared to waive any objections I might have today or in the future on this aspect, and I'm sure the same
But once the judge recuses, then we can force her to take up the matter. That's a problem.
True, my lord. True, my lord. In fact, I had made the submission before her previously also, but she said it may not look proper if I take up the matter. So I'm sending it to the Honorable High Court. Let the Honorable High Court decide on this aspect. So what I'm humbly submitting, my lord, I'm prepared to make a waiver to waive any objection I might have today or in the future on this aspect. And I'm sure my friend would also make the same submission. If both parties waive any objections on this aspect, my lord, I think the judge would be free to take up this matter subject to what lordship decides, my lord.
May not look nice.
Very well. Very
So which court is the nearest court?
Nongpo.
Nongpo, man.
MACT Nongpo.
My lord, I have also a small submission. Since this is a very old matter, my lord, this is the motorization claim of 2009.
10 years, 2013 is the case number.
So let it be a time-bound exercise, my lord.
So we'll request the MACT judge to take up the matter at the earliest point of time. Oh, since so-and-so has recused on the ground that she is related to Ripna, was once counsel for the complainant, and that the parties have agreed that the matter may be taken up by the judge who is hearing MACT at Nogba. So both counsels submitted that the integrity of the officer who is recused of matter is not in question, and that they have no objection in the same judge in taking up the matter. Since the presiding officer has recused, we do not want to compel the judge to take up the matter. Further submitted that the MAC case is of the year 2009 and that the accident has taken place in 2008. 2008, you know?
2008.
2008. And that they requested that speedy trial may be conducted.
My lord, it is fixed for final arguments.
Only for final arguments?
Only for final arguments, my lord. In fact, I have punishment.
Submitted that that matter is posted for arguments. But 2009, the matter is posted for arguments. Posted only for arguments. Taking note of the fact that the matter is of the year 2009, more than a decade old. We expect the presiding officer, new presiding officer, to decide the matter and pass final orders within a period of
3 months?
4 months from the date of register of the order.
No.
Would lordship be kind enough to fix a date for parties' appearance in Nongpo, my lord?
The records will have to be sent, you know.
The records are here.
Records will have to be sent. Once I think by next week it will reach. But papers from here, we have got only the letter and other communication. The papers from the other court will have to reach the Nongpa.
Lordship, I believe the records are before this.
Records have come. So the registry is directed to forward the records. Yes.
Published.
Item number 2.
Records within a period of 1 week from today.
Published.
Please, Your Lordship. May it please, Your Lordship.
Yes, sir.
Yes, my lord. Item number 2 and 3 pertains to the same writ petitioner, my lord, who has expired in the meantime. So his wife is representing, my lord.
Legal ads have come on record.
Am I audible?
Yes, you are audible, sir. Legal ads have come on record.
Yes, ma'am. Yes, his wife is there, my lord, already substituted.
Oh, wife has got substituted in the place of the deceased.
Yes, ma'am.
Yes.
Has been substituted, my lord.
Yes.
Now, the first case, my lord. the 494 of 2021.
There's some confusion, my lord. This is supplementary.
So I think you're addressing some other case.
Yes.
The paper doesn't.
Oh, I'm sorry, ma'am. I'm sorry.
The supplement list, no? We are calling from the supplement list. You are the main list. You will.
I apologize, madam. I'm sorry. I'm sorry, madam. I'm sorry.
Yes.
This is an writ petition against a termination of service, my lord. My lord, here the petitioner, he was enrolled in the Assam Rifles in the year 1974. But in the year 1993, when he was...
This case came up yesterday.
My lord, yes. My lord. I apologize for my absence yesterday.
Yes, somebody represented one.
My lord, yes, I had made a request.
Yes.
No, my lord, in 1970...
You served for 19 years.
I served for 19 years, and thereafter, my lord, I was taken into police custody while I was returning back from my leave. Now, this fact was also known to the respondents at that point of time, and thereafter they had also, I had reported to the unit, and they had asked me to come back with my proof of innocence. Now, my lord, I could never get back to that case, what happened to that original case where I was arrested, because at that point of time, my lord, the judiciary and the executive in the trial courts, my lord, they were the same. My lord, the same.
What happened to the criminal case?
My lord, from their affidavit in opposition, it appears that a final report was submitted. So nothing actually came out against me anyway. It is their affidavit in opposition. I could not trace out anything from me, my lord. Now, when we wrote a letter for asking for my reinstatement.
But you have not been there for more than 5 years.
My lord, that is what, my lord. 1993, I was arrested. 1995, I got my bail. 1996, I reported to them that I have come. They say you come back with your proof of your innocence. 1998, the DGAR again orders an inquiry into my case. Till 2003, no inquiry is made. I am not let known anything. I am not said anything. 2003, they passed an order dismissing me with retrospective effect.
Retrospectively?
With retrospective effect. They dismissed me. Now, when I say that please take me back in, they say that we have already dismissed you. Nothing doing. Don't come back to the.
How many years of service is required for pension benefit?
20, my lord. 20. I was around 6 months short when I was dismissed.
So more than
even if I take
19 years and 6 months and above.
6 months and above I had done. If we take the date of the retrospective dismissal order also, if we take it as on the date on which I was actually dismissed, then my lord, from 1974 till 2020.
But for the dismissal order, are you entitled to pension?
My lord, no.
Are they?
I was not that.
When was the dismissal order passed?
2003, my lord.
So by that time, how many years you have completed?
My lord, I would have completed 30 years of service. 29 years, some months. Nearly 30 years of service I would have completed. And if it is taken from the date of the date on which they have given the effect, I'm only paying, my lord, if my termination as of 2003 or 1993 can be taken as a compulsory retirement also. I am entitled at that point of time to some pension which I will draw to then live my life, my lord.
Yesterday I was suggesting to you.
That is the long and short of it. That is what my praise also. Only the pensionary part is what.
Two facts I'll place, my lord. The conduct of the petitioner, my lord. Even the conduct of the petitioner, my lord. How he tried to mislead the department, my lord. My lord, here what happened, my lord. He went on leave for 20 days, my lord, in the year 1993.
Yes.
He was supposed to join back on 28th of October 1993, my lord. 20 October 93.
You give the list of events.
My lord, that lordship would find at the writ petition, my lord, immediately below the synopsis. I had given one, my lord.
Synopsis.
Immediately below the synopsis is a list of data and events, my lord. He might like to add something to it. That is overall the list of dates.
Yes. 74, he joined the service of Assam Rifles.
My lord.
20 days leave on 110, so on. So, yes.
So you were supposed to join back on 20th of October 1993, my lord. Now, thereafter, what happens, my lord? Very interestingly, the unit receives a letter from one underground outfit, my lord, saying that the petitioner has been kidnapped by them and demanding ransom money of 50,000 rupees.
Who has been kidnapped?
The petitioner.
The petitioner, my lord.
Petitioner was kidnapped.
Yes.
That is what he is saying, my lord.
No, that letter is also on the records. That letter they have admitted. That lordship will find the affidavit in opposition at page 25. We got the ransom note. My story, my lord, if I have to give the fact, my story is.
I'll just complete.
Wait, we'll hear you. Yes.
Page 25, lordship sees, my lord.
Page 25.
25 of my affidavit, my lord.
The order dated 14 November 2021.
My lord, page 25 of the affidavit, my lord.
Your affidavit. Huh?
My affidavit.
Page 25.
25, my lord, annexure 2.
Oh, yes, annexure 2.
Now, this reads, my lord, as you are aware, an inland letter was received by this unit dated 21 November 93, signed by one Mr. Y.G. Sema, claiming that N.K. Achelal, who is the petitioner, my lord, of this unit is under his custody since 5 November 93. A ransom of rupees 50,000 was demanded from this unit, and the money was to be paid by 15 December 93, failing which the individual was to be killed and his dead body sent to Kangla Park Gate, Imphal. Consequently, an individual of this unit was sent to the home of N.K. Achelal as to find out whether the individual is still at home. If not, his whereabouts and the date on which he left his home. It has been reliably learned through wife of the individual and also from Gram Panchayat that the individual had left his home on 6 November 93. His wife has received 2 letters from him thereafter, and the second letter was written on 28 November 93. Certified true copy CTC of the same is enclosed herewith for your ready reference from the post office stamp on the letterhead, and also the text of
What about the para number 3? For para number 3, what is how are you going to establish?
My lord, what happened, my lord? He went home with no intention of coming back, my lord. So what he does, because he knew that he'll be dismissed from service now, or a disciplinary action will be taken, he makes a false story, my lord, that he has been kidnapped by militants in Manipur. My lord, that will further be proved, my lord. I'll point out some more documents, my lord. Can I just refer to...
Was he involved in a criminal case?
Yes. Actually, what happened, my lord, he was arrested for drug peddling, my lord, at that time.
Well, what happened to the case?
My lord, their affidavit says it.
1 minute, sir, will come.
So, my lord, he was arrested for peddling ganja, my lord, by the Narcotics Authority in Manipur. So he made a false story because once somebody is arrested in a criminal charge, my lord, he will be immediately placed under suspension. So just to cover up all these things, my lord, he makes a story. Now, my lord, more importantly, my lord, the lordship kindly comes to...
So whether, did you conduct inquiry?
We conducted inquiry, my lord.
Department inquiry?
My lord, departmental court of inquiry, my lord, under the Assam Rifle rules.
Yes, court of inquiry.
What we found, my lord, that he was still at home on 20th November when he was supposed to join.
So you have dismissed him service on the ground of absence, not for drug peddling.
Yes, on the ground of absence, my lord.
So he was arrested, he must have come out on bail, all those things will be there.
Now, my lord, initially he was declared as a deserter, my lord, because it's...
Why should you deprive him the pensionary benefits for the actual services rendered? He has rendered 19 years of service, 19.5 years of service. You pay him only that.
My lord, our case is, my lord, so if somebody is dismissed from service, my lord, he is not entitled to any pension.
No, convert the punishment to one of compulsory retirement. He will be entitled to 2/3 pension. Suppose I disagree with you. Then the entire period of, so how can you pass an order of termination with retrospective effect?
But the order of termination was passed, my lord, because the rules require, my lord, if somebody does not turn up, my lord, after going on leave. So we have to maintain him on supernumerary strength for 5 years, my lord. That is in terms of the Assam Rifle Act and rules.
So 5 years will have to be included.
So, my lord, after 5 years, you have to...
5 years will have to be included. Supernumerary post.
My lord, but when he is dismissed from the date, my lord, the original date. Because 5 years only to see if he comes back, my lord.
See, give a quietus to the matter, sir. Pay him, convert it to one of compulsory retirement, pay him He'll be entitled, I think, 2/3 pension. Is it not compulsory? If we pass an order, you'll have to pay full pension.
Because otherwise he has not completed 20 years of service, my lord. He is absent since 93, my lord.
When did he join? 1974.
1974, my lord.
1974.
26 for 1974.
1993. 74 to 23 is 19 years. From when he was absconding?
So 2010-93.
2010?
93.
20, we'll see the list of dates. April, May, June, July, August, September, October.
So short by 6 months, my lord.
6 months. Huh?
If the date of termination, the order passes.
2 years, 19 years and 6 months.
Right.
So 6 months and above can be treated as rounded off to 1 year. Where is your pension provision?
Well, we were next one. We are referring to Rule 24, my lord, of this.
Where is that?
Page 148, my lord, of the second last, page 60, my lord.
140?
The second last page of my affidavit, my lord. It is page 60, I think, my lord.
60.
My lord.
Counting a period of suspension.
24, Rule 24, my lord, at the bottom.
Dismissal or removal of government servant from 4 pages. Yes, is not entitled to pension, correct. Compulsory retirement? I'm sorry, unless allowed withdrawn, entitled to forfeiture of the resignation, not forfeiture relief.
My lord, if you lots of grants me 10 days time, my lord, I'll have instruction if they can reconsider it, my lord. As per the observation of your lordship.
See, give a quietus to the matter, sir. Where is the rule pertaining to compulsory retirement?
No, that has not been annexed, my lord. But I'll come back, my lord. If lordship grants me 10 days, my lord, I'll ask the department if they can convert it into compulsory retirement and grant him pension at least. If he's not asking for restatement or other.
I'm not asking for restatement.
Heard both parties. According to Dr. Moshika, the petitioner was served for 19 years and 6 months, who went on leave for a period initially for a period of 20 days, ought to have reported for work on 20/10/1993, and that in order to escape from the criminal case which was foisted on the petitioner, who was taken to custody for drug peddling, did not report for work since 2010/1993, that is a deserter. Stop. The petitioner has created a story that he has been kidnapped for ransom, and that the pleading of the petitioner is disproved by the facts pleaded before this court, and that the petitioner was found to be keeping 30 kilos of ganja. Also, the counsel appealing for the writ petitioner refuted the contention of the petitioner, and that would submit that if the punishment is converted into one of compulsory retirement for the actual services of 20 years, as the writ petitioner has completed more than 19 years and 6 months of service, the issue can be given quietus to. Dr. Mosika sought 10 days' time to ascertain from the respondent as to whether the punishment could be modified. Stop. Close the matter after 2 weeks. Give a quietus to the matter on all these things and all. See, you're going to, that person is alive?
Well, he is alive. He is now 60, around 65 years of age, 65 to 66. The issue of reinstatement would not be there, Malad.
Take into account the families. That's all. Take over for the anyway, you are not taking action. The criminal, there is no criminal case. Nothing is there.
Well, even wife is conspiring in making that story, my lord, that he was kidnapped.
That is right.
Is it have come truthfully, my lord, that this is what has happened?
No, I was able to see that. I was able to see that about you were not also reported for 5 years. That's a finding.
They required me to come back with proof of my innocence. There is a letter from them. My innocence. From the court. That letter is on record. They refused to allow me to join or even conducted an inquiry against me after.
So even if a case is registered,
my lord,
definitely you will get the benefit of doubt.
Yes.
A benefit of doubt will not lure them to give the benefit.
No.
Still they are entitled to proceed for department.
Against me, my lord. They did not even allow me to rejoin. That is the whole thing, my lord. I could have come up with something perhaps. If
No, that there is a session of employer-employer relationship. You cannot even proceed against you. For the 29 years of service, you will have to pay. You are quite used to the matter.
Well,
I'm deeply obliged.
Deeply.
Item number 3.
There were 2 cases. Dr. Mosika, you have got, I think, 2 cases. Your name was there. 2 or 3 cases, yes. Yes.
May it please your lordship.
That
lordship.
appearing was got elevated to the way, is not aware who is going to appear for the respondent.
Your lordship, here the petitioner was dismissed from service by the due dated 14 January 2000.
What is the charge against you?
Charge was their negligence of duty, your lordship.
What is the post you are holding?
Constable, your lordship, in Meghalaya Police.
Yes.
So here, your lordship, the brief fact of the case is that I was dismissed from service on 14th January 2014, and after dismissal, your lordship, I came before this honorable court, and my dismissal was set aside by the honorable High Court by the order dated 5/4/2018, the annexure 3, page number 23, your lordship, to my writ petition, annexure 3. Annexure 3, page number 23.
Dated?
Dated 5/4/2018, your lordship. It was the dismissal order was set aside by the
page number?
Page number 23, your lordship, and the order is 25, para number 6.
25, para number 6. Yes.
After hearing the submission advanced by the learned counsel for the parties and keeping in mind the fact and circumstances of the case, I hereby set aside the dismissal order dated 14/1/2000.
They will ask to conduct a fresh inquiry.
Yes, your lordship. And here the dismissal order was set aside, your lordship, because the DP was drawn under the repealed act and the rules. The first DP was drawn by the order dated 23rd July 2013.
It was dropped.
No, it was drawn, your lordship.
It was?
The first DP was drawn First, yes, Your Lordship. The first DP was initiated.
Initiated.
Yes, Your Lordship. Initiated under 18 Police Act 1861, which was repealed while the Meghalaya enactment 2010 came into force from.
When was it repealed?
It was repealed on. It was repealed by Meghalaya Police Act 2010. 2010 came into force. It was notified by got the assent of the Honorable Governor on 4th February 2011.
Where is it?
Here I have not annexed, Your Lordship, I can provide.
Oh. But is there any saving clause?
Yes, Your Lordship, there is a saving clause.
Saving clause for the action taken prior to that, because you have been dismissed from service prior to that, is it not?
No, Your Lordship, I dismissed from service after
on 14/1/2014.
2014, and the act was repealed in 2011, Your Lordship.
2011.
Yes, Your Lordship, and it came.
So after the repeal act, they have taken action.
Yes, Your Lordship, and it was repealed and it came into force by the 7th February 2011.
7th. Yes.
7th February 2011, the Meghalaya Police Act came into force. I was dismissed from service.
So what happened to the? Okay. They should have taken action under this act.
Yes, Your Lordship.
They have not taken action under this act.
No, they have taken action under the Repeal Act. It was not in force.
What is it? How many years of service you have rendered?
12 years, Your Lordship.
12 years of service.
Yes, Your Lordship.
Yes. What was your age at that point of time?
I was 34 years.
34 years.
Yes.
Yes.
Worship, this issue has been laid to quietus because of the notification and the judgment of this Honorable Court. The relevant paragraph of the judgment would be page 27.
Notify. So by the time the notification is issued, you proceeded under that act. No, but all act taken under the act goes.
No, Lordship. Lordship, we'll kindly come to this, the issue settled in the judgment there again, Lordship, paragraph 27 onwards, 27, 28, 29. Paragraph 27.
Oh?
I've given a judgment of 2021 SSC online, Meghalaya 94.
27, 1 minute.
Paragraph 27, 28, 29. 27, 28, 29, 30. Lordship, the main issue is at paragraph 23. The issue raised.
Yes.
Issue is at paragraph 23, but the answer is at 27, 28, 29, 30.
Sir, what do you say? I've been asking you a simple question regarding repeal provision. Repeal provision is mentioned in para number 29. Notwithstanding such repeal, anything done or any action taken under the Act so repeal shall deem to have been done or taken under the corresponding provisions of this Act.
Your Lordship.
So, you have been dismissed from service. 2010 Act 2014 you have been dismissed from service.
Your Lordship.
2010 Act was not in force when the dismissal order was passed. It was given retrospective effect in 2015. In the light of the repealing provision, the act done was perfectly in order.
Your Lordship, I will come here. Your Lordship, my offence was committed in 2013. For the DP, for which the DP was drawn, for the offence, the neglect of duty, the offence was committed by me, the alleged offence, on 17th July 2013. DP was drawn on 23rd July 2013. I was dismissed from service on 14 January 2014, Your Lordship.
Correct.
Under the Police Act 1961, under Section 7 of Police Act 1861 in 2014. Your Lordship, this Act, Meghalaya Police Act, came into force with effect from 7th February 2011, Your Lordship.
Correct.
7th February 2011.
Correct.
So before 7th February 2011, no DP, no action was initiated, no offence only was committed, Your Lordship. Before 2011, there was no offence committed. I was nothing, nowhere I was involved.
So that
and section, the Police Act, Meghalaya Police Act, section 136, Your Lordship.
136 of?
Of Meghalaya Police Act.
161.
136.
136.
136 has given the repeal and saving clause, Your Lordship.
1 minute. Yes.
Here, Your Lordship, it says 136 subsection 1. The Police Act 1861, Act 5 of 1861, in its application to the state of Meghalaya, and the Meghalaya Village Defence Organization Act 1966, Assam Act number so and so, as adopted by the government of Meghalaya, are hereby repealed.
Correct.
I hereby repeal. Your Lordship, again, if Your Lordship will peruse the section 3 of the Act, it says, Your Lordship, it shall come into force on such date as the state government may, by notification in the official gazette, specify in this behalf.
Correct, sir. We agree with you. Everything, all points we agree.
Yes, Your Lordship.
Only thing is, you are not reading 136.2. You read 136.2. That is against you. Absolutely. So that is why when the matter was started, when you comment your argument, I asked you about the repealing provision.
Yes, Your Lordship. This saving clause, subsection 2 has given, Your Lordship, whatever the action has been initiated against any person prior to 2011, Your Lordship.
Sir,
prior to 2011.
Any action initiated prior to 2011 or prior to the date of notification in 2015 will continue in terms of the 2010 Act.
Your Lordship.
If they have a similar provision, correct? Lordship. So the entire thing cannot be dropped.
There is for that also the government notification dated 9th July 2015 is there, Your Lordship. You have another copy.
Stating?
Here it says, Your Lordship, the government of Meghalaya Home Police Department, order by Governor, notification dated 9th July 2015.
Yes.
HPL, letter number HPL 181/2003.
So what is it it says?
Says, Your Lordship, pending final, not this one. In exercise of the power under subsection 3 of section 1 of the Meghalaya Police Act 2010, the Governor of Meghalaya is pleased to notify that the Meghalaya Police Act 2010 is deemed to have come into force with effect from the date of its publication in the Gazette of Meghalaya on 7th July 2011.
The power of the Governor under the Act.
Yes, Your Lordship.
Under section 3. under 3.
My question is that, Your Lordship, that here 2015 letter also says that the Meghalaya Police Act came into force with effect from 7 to 2011.
Sir, I agree with you.
2011. So, Your Lordship, how the action, once the act came in 2011, how the action can be taken against me in 2014 on the Repeal Act, Your Lordship? In 2014, Police Act 1861 was not existence. In 2014, Your Lordship, the Police Act 1861 was not in existence.
So that's a submission.
That's why I'm saying, Your Lordship. In 2014, Your Lordship, the Meghalaya Police Act was in existence.
Understood. You understood, sir.
So how they can take action after 4 years of coming into force this act under the Repeal Act, Your Lordship?
You don't ask me the question. Yes. Come. The present writ petition has been filed by the writ petitioner challenging the act of the respondent and dismissing the services of the petitioner with effect from 14/1/2014.
May I please, Your Lordship, if I will be allowed to say a few lines, Your Lordship. Your Lordship, that matter was settled and the order was passed in 2018, Your Lordship, by dismissing the, setting aside the dismissal order.
Setting aside the?
Dismissal order, Your Lordship. The dismissal order was set aside on that ground.
Set aside on which ground?
On that ground, Your Lordship, that the DP was initiated against Repeal Act by the order and judgment dated 5/4/2018 by the Honorable High Court only, Your Lordship.
By Justice Sen?
Yes, Your Lordship. Para number 3. Annexure 3, page number 23, Your Lordship.
23.
And the para number 6. It was already the dismissal order. It was set aside on the basis of that only that the action was taken under the Repeal Act.
You do not prefer any appeal. State does not prefer any appeal against this order.
No, Your Lordship.
Yes.
Then thereafter we approached the department, police department, to reinstate into service. Or it was said in that para.
They have not conducted any inquiry thereafter.
They have initiated inquiry, but now they have initiated inquiry against the judgment of this, Your Lordship.
What do you mean against this?
This order said, this order, Your Lordship.
Where is the inquiry proceedings?
Yes, sir, this one is set aside, and here Your Lordship said.
When was the inquiry commenced?
Then again, new inquiry was commenced in 2019, Your Lordship.
2019.
2019, Annexure 5, page number 35, Your Lordship. Page number 35.
It's 26th March 2019.
26 March, that is correct, Your Lordship. So here, Your Lordship, the judgment said that the first inquiry may be conducted under Meghalaya Police Act. But 26 March 2019, Your Lordship, the memorandum was issued and there is no act.
Yes. This is the memorandum issued. Where is the inquiry charges?
There only, Your Lordship, the page number 36 and 37. Page number 37, Your Lordship. 37 and 8, the allegation of charges are there.
Which order is under challenge now?
Now we are challenging the order, Your Lordship. They are intending me to dismiss from service. Why the page number 42, Your Lordship, Annexer 7. They are intending to dismissing me from service on the rules, under the rules, Your Lordship, not under the Act. There is no penal provision, Your Lordship. The Honorable High Court earlier has directed.
Submitted by him. Inquiry report is also enclosed. Carefully inquiry report. Money for inquiry officer. Center for not living 15 days.
Page number.
Sir, what do you say, sir? Why you have not given him an opportunity to submit comments on the inquiry officer's report?
No, Lordship, we have taken a specific plea in the affidavit, Lordship. He never turned up.
Where?
After the second show cause notice, it's a specific plea.
No, the show cause notice.
After that, he never turned up, Lordship. He chose to abandon the.
So you have not passed any orders?
No, we passed it subsequently when he abandoned and never turned up. Then the statement of the witnesses were recorded and then the order followed.
What is the order passed by you?
Order? Page 36, Lordship.
Huh?
Page 35.
35 of?
Of the writ petition.
35 of your writ petition.
Lordship. This one? This one. 26 March 2019, Lordship.
So usually action will be taken. What action you have taken? You said the inquiry will be conducted ex parte in case he fails to appear. What is the order passed?
The order, Lordship, the order passes the next.
Sir, you see up to page number 42, if you see, no final orders have been passed.
Lordship, yes.
What is the charge against you? Sleeping on duty.
No, Your Lordship, one UTP was run away from the cell. UTP, Your Lordship.
Gross negligence, Your Lordship.
UTP was run away from the cell. UTP, under trial prisoner.
Under trial prisoner, Lordship. He is supposed to protect.
Later he was arrested from Kolkata. Now he already died, Your Lordship, expired.
It was a gross negligence of duty, Lordship.
And that also I was not aware.
But why you not conducted inquiries, a proper inquiry?
Now,
no proper inquiry at all. Where is the evidence?
Lordship, we as a cemetery, Lordship, when the show cause notice was given, he filed a reply and he chose not to participate in it.
Correct. He has not participated. He has not participated.
Collected all the
You cannot examine your witness.
We have examined, Lordship.
Where is it?
We examined. Lordship, if need, we will produce the original records.
Where is it?
No, we'll produce the original records of the inquiry, Lordship, to satisfy the court.
And final orders have not been passed.
That has been...
Sir, you must understand that once the inquiry is over, after the inquiry report is submitted by the inquiry officer, the duty of the disciplinary authority is like a postman.
Absolutely, Lordship is correct.
He will have to forward a copy of the inquiry report to the delinquent, ask for his submission. Which you have not done yet.
We
have proposed a punishment.
Lordship, allow me to produce the original records which will satisfy your Lordship. That was done.
How many years he has worked?
Lordship?
How many years he has worked? 12 years.
Yes, Lordship.
Why don't you take into account the minimum years of service and extend the pensionary benefits?
Termination.
Otherwise, we'll have to set aside the order. See, firstly, order of Justice Sen is wrong.
Lordship, that has been observed, the judgment that I gave it to your Lordship. Lordship will kindly see the para 30 for a moment.
Para?
Para 30. For a moment, Lordship. 2021.
Para?
30.
30.
The above read jointly with the contents of the said notification 9/7/2015 would show that at that time when the disciplinary proceedings was initiated against the petitioner, Part 1/6 of the Assam Police Manual is still applicable. It may be mentioned that this court, with due respect, would say that had this notification been brought to the notice of the then Honorable Judge in the case of the Justice Sen's order, Your Lordship, the outcome would have been different.
Right. Now, if he has challenged the order of the year 2014,
Lordship,
I would have dismissed the case.
But he has challenged 2019. Lordship is correct.
Justice Sen has allowed, whereas I would have dismissed it. Because in terms of 136 clause 2, repealing provision is there, and action already taken is correct.
Even 71, Your Lordship. Lordship, for a moment, sees 2010-71. 2010 Act 71 clearly takes care of this issue raised by Section 71 of the 2000 Act. Police Act.
That is right.
Right.
But now the order has been set aside by the single judge, that has become final.
Absolutely.
So you will have to proceed in terms of 2010 Act. Then impose the punishment.
Lordship is correct. Lordship, allow me to produce the record because right now we don't have the record. We'll try to address the issue, Your Lordship, whether this was done properly or not.
It's a very serious offence and you are taking it very lightly.
We will have to go through
See, I have been seeing lots of inquiry proceedings that are coming before me in the petitions. There is no proper conduction of the inquiry proceedings at all.
Lordship, there has been one more matter, Lordship has dealt with it, that jailbreak matter. Same thing, there was a lapse in the
The
inquiry.
problem is there. It's a very serious offence.
Absolutely.
Taken very lightly.
And can we have the report?
I am going to hold that the order of Justice Sen in this case may not be correct, but it has attained finality. Now I will not be in a position to upset the same. That's what I am going to say. You have got a good case, you are not preferred an appeal.
Lordship is correct. No, but Lordship, then we have got two, this SM Roy judgment in Lordship, para 30 clearly says. So we have got two judgments. It could
But here there is no finality attained.
No, no penalty.
There is no finality. You have not passed any orders.
Absolutely. Your Lordship, we'll just try to verify from the record what exactly happened. Right now, we have not taken the plea. Only thing is that, because it was proceeding ex parte, never participated. So whether how the stage.
That is right. Ex parte means there should be an ex parte order.
Absolutely.
Where is the ex parte order?
Lordship, we'll have to verify from the records. That part we have to see.
And after page number 42, what happened next?
Absolutely.
We don't know. He has approached this court and there is no stay. You would have passed final orders.
Absolutely. Lordship, kindly grant us a week's time. We'll try to produce the record. We'll try to verify.
Matter, according to the petitioner, he was dismissed from service on 14/1/2014, which was set aside by this court on so and so date in WP number so and so. The order has become final. The petitioner would further submit that instead of taking action pursuant to orders of the court in terms of Meghalaya Act 7 of Meghalaya Police Act 2010, which came into effect from February 2011. As the said act received the assent of the governor on 4th February 2011, which was published in the Gazette of Meghalaya, Extraordinary, Part 4. Come on. Action has been initiated in terms of the rules. Full stop. The petitioner has come forward with the decision, a proposed decision of dismissing the petition from service. The counsel appearing for the respondent, Additional Advocate General appearing for the respondent, would submit that he will produce the entire file, and that in terms of 136(2) of the Meghalaya Act 2010, action taken before repealing would deem to have been done or taken under the corresponding provisions of this Act. Stop. Though we agree with the continued Additional Advocate General that the dismissal order passed on 14/1/2004 is perfectly valid, but unfortunately the same has been set aside and no writ appeal has been preferred against the said order. Stop. The continuation of the petitioner that the once Meghalaya Act 2010 is notified on February 2011, with effect from February 2011, pursuant to notification dated 17 June 2015. The dismissal order dated 14/1/2014 shall go. Though we don't agree with this contention, as stated Subra, much water has flown and that no appeal has been preferred by the state, that against the second choke was noted, the petitioner has approached this court in order to enable the state government to produce relevant records on the present status of the disciplinary proceedings. Close the matter after 2 weeks. A pleasure. You got a very good case. You got a very good case and you have not done anything. You should have preferred an appeal.
Absolutely, Lordship.
Item number 4.
Each and every act will have a repealing provision. That is why when you argue the case, started the argument, I asked you about the repealing provision.
Next date again, I will argue, Your Lordship. I will come well prepared and I will argue this.
No. Insofar as, see, that issue is concerned, that has become final.
Yes, Your Lordship.
Suppose in place of Justice Sen, I were there, I would have dismissed your petition.
Your Lordship.
Because the act, anything the act is done, that has become final. Suppose, take a criminal act. Conviction is imposed based on a particular section.
No.
He is in incarceration. And Supreme Court at a later point of time set aside the provision. The act done is done. That is all.
Absolutely. Your Lordship,
Yes.
Something has repealed today, and today onwards another new act has come. And tomorrow I will commit any offence, Your Lordship.
No, subsequent action, the disciplinary action, they have to proceed under 2010. That we agree under similar provision.
Yes, Your Lord.
That I agree.
So my offence was committed in 2013.
Sir, you got 2 parts. One is 2014 order, the other one is 2018 action.
Yes, Your Lordship.
2014 at a certain finality.
Yes, Your
So
Lordship.
with regard to 2018, they will have to submit what the action they have taken.
Absolutely. Even 2015, by the notification, the statutory provision of that cannot be stated.
Anyhow, you also try to settle the matter.
Yes, Your Lordship.
What have we tried to settle the matter?
Absolutely.
Ultimately, it requires pension. The problem is generally, if it is a private party, then we can persuade settlement.
It comes to state, Lordship.
So state may not agree.
Absolutely.
Suppose I don't agree with you, then naturally you'll have to get all the benefits.
Lordship is correct. We will explore the possibilities. Let's see what can be. Oblige deeply.
Item number 4.
My Lord, before beginning, my Lord, into the merits, I am being informed that, my Lord, a similar matter, Dr. Moziga might be able to throw light. This thing has decided a similar matter, my Lord, where the writ petition has been dismissed. These were cases, my Lord, where these petitioners were dismissed or, my Lord, discharged from service because of not medical fitness.
I think
was
this is a
done in
case you have
exercise
already
of-
argued. This matter, if I remember
Yes,
correctly.
my lord, I did.
With regard to 21 employees or 22 employees.
My lord, in the meantime, what happened, my lord, similar matters were pending before Justice Thank you also, my lord, and those have been disposed of. I am placing those orders, so that will cover, my lord, this matter also.
This matter also.
My lord.
What relief have been given?
My lord, the relief that has been given, my lord, here what happened, my lord, initially.
You agree that the order covers your case also?
It's an identical case.
My lord, I am bound by that order, my lord, though I would still like to argue, my lord, that the policy that has been already set aside, my lord, was a decision, my lord, taken in rem, and therefore I am hard done by the policy. Wrong.
Covered. Accordingly, in terms of the judgment of the order dated so and so passed, the order director to examine the aspect of payment of allowance of the petitioner. See, if you are going to argue, you may lose the case. This order,
my lord,
squarely covers, my lord. Justice Thank you is granted, my lord, because of the stay order passed by this honorable court, my lord. When they initially approached this honorable court, they continued in service for about a year, my lord. So the direction which is given.
What do you say, sir, Mr. Chakrabarti?
Mr. Pathak.
Mr. Pathak, my lord. My lord, I understand, my lord. We are hard done by.
It comes as Chakrabarti. Oh, there, Pathak. Yes, Mr. Pathak. The two different names appear.
My lord, we are, my lord,
It appears
we are
as
hard done by a
yes.
technical rule that we just simply could not prefer an appeal, whereas the persons who had preferred appeal and all others, my lord, because the entire policy has been now scrapped, they have benefited from the fact that they cannot or they could not have been discharged, my lord, under Rule 48 without taking recourse to Rule 26 of the Assam Rifle Rules. But then, my lord, what Justice Thank you has decided, and in our case also, my lord, the deficiency we suffer, admittedly, is that we preferred a writ petition initially that was dismissed, and thereafter, my lord, we could not prefer any appeal. Though ultimately the entire thing, an exercise done by the Assam Rifle was found out to be wrong by various courts. And in fact, Assam Rifle...
Are you ready? You can argue the matter.
My lord, we are hard done. I understand, my lord, we are bound by Justice Thank you's judgment on this issue. But then we are, my lord, basically hard done by the technical rule of res judicata that we came earlier, my lord, in a single bench.
So, see, if you say that it is covered, I will pass order based on the order of Justice Thank you. If you want to argue, you must convince the court that insofar as your petition is concerned, that has attained finality, against which you are not prefer an appeal.
My lord.
So it's hit by res judicata. That was the submission earlier made.
Yes, my lord.
My lord.
So in the process, what happened? You will not get any benefit based on the orders of Justice Thank you.
My lord. That is where I also stand, my lord, on facts.
Huh?
That is where I stand on facts, my lord. But the only thing is that the policy itself having been found wrong, my lord.
We cannot go into that. Policy is wrong.
My lord. That aspect, of course, my lord, as of now, might be difficult.
What do you want me to do? Do you want me to follow the order of Justice Thank you, or do you want me to pass orders?
Lordship would pass orders accordingly.
Accordingly means what do you mean by take into account both the. So
my lord,
I say that this is hit by res judicata. However, you are going to extend the benefit to the person, writ petition, based on orders of Thank you. Can I say that?
My lord, Justice Thank you passed two orders, my lord. You lord, there is a one-page order also. If a similar order is passed, that will suffice, my lord. A short order is there, my lord.
Oh. He was a party to that.
My lord, here what happened, my lord?
No, he was not a party. This person was not a party there.
In this proceeding, no, my lord. But facts and circumstances are similar.
No. That is right. The writ petitioner herein was not a party there.
Originally, he was a petitioner, my lord.
Originally, not in this order.
No, my lord. Not in this one.
So, shall I pass orders? The same lines.
My lord. My lord.
Thank you.
My
lord. The present writ petition has been filed for the following relief. several petitioners, including the present petitioner, have approached this court for the relief, and all the writ petitions were dismissed on 15/3/2016. The present writ petitioner was concerned in WP 59 of 2012. All others except the present petitioner preferred a writ appeal, and the writ appeal was allowed and writ petition was restored to file. On remand, 21 petitioners, excluding the present petitioner, got favorable orders. Against the order of dismissal dated 15/3/2016, the present petitioner has not filed any writ appeal, and insofar as he is concerned, it has attained finality. For the same relief, another writ petition has been filed in the 2020-21, which is now tried by this court. The main contention of the respondent is that once the writ petition has been dismissed and has attained finality, for the same relief, another writ petition is not maintainable and the same is hit by res judicata. I find much force in the contention of Dr. Mosika appearing for the respondent. Full stop. On demand, some of the petitioners have got relief full stop. During the course of argument, both the petitioners were presented the order of this court dated 5/4/2024 in WP 291 of 2023, extending relief to the writ petitioners. Mr. Mosika submitted that the relief granted in the said writ petition will be extended to the present writ petitioner also. The counsel for the writ petitioners, though fairly submitted that there appears to be hindrance on account of the principle of res judicata, the benefit of the order dated 5/4/2024 in WP 291 of 2023 and 9/4/2024 in WP 181 of 2023 may be extended to the writ petitioner also. As the respondent has agreed to extend the benefit of the orders, if the petitioner is otherwise found eligible, the writ petition is disposed of, directing the respondent to complete the exercise in terms of the orders of this court dated 5/4/2024 in WP 291 of 2023 and 9/4/2024 date in WP number so and so. That's all.
Well, deeply obliged.
Yes.
Deep.
From the daily list, item number 1.
In fact, Mr. Mosika, I want to say that though serious offences are committed by the employees on account of drawbacks and lacunae conducted by the department with regard to conduct of inquiry, the court will have to naturally interfere. And please ask somebody to address the issue. Ask them to take classes through the disciplinary authorities as to how the inquiry proceeding should be conducted.
But as far as paramilitary forces are concerned, my lord,
in the previous case, AIG appeared. Another case where I've interfered.
State government, my lord, there is some problem. But as far as
whoever it is, see, anybody, can attend the course and
training courses, my lord.
so that it will be, you can ask the advocates or somebody to address. So there are some good lawyers in Chennai. We can ask them to the Judicial Academy. We can ask them to address some classes.
State government officers.
Very important.
They're very good, helpful also, even for lawyers also.
Similarly, in criminal cases also.
Criminal cases are very bad.
Also some thing. The day Chief Justice of India was giving one illustration about how a junior who stood as state first in law and wanted to do the cross-examination, and the senior advocate was not just Chief Justice of India, Chief Justice of Madras High Court, Justice Gangapurwala, recent address. A senior advocate was there. And there was a murder. And after seeing the witness, the lady was wearing thick glasses. So the counsel went 30 feet. I can say, are you able to see me? No. Then after 20 feet, they say, are you able to identify me? No. 10 feet. He said, no. Then they said, finished. That's the end of it. Then it was an eyewitness. Then there was no proper evidence at all. The junior he told the junior, he said, don't ask any further question. We have got a good case on merit. Junior said, no, I have stood first in the university. So I must also ask some question. He asked, when did you start wearing the glasses? He said, I met with an accident last week. Thereafter I started wearing it.
Well,
so entire case gone. So you must know what case questions should be asked, what questions should not be asked. So that will be taught to the. See, in some cases, you take several murder cases, it will be, many cases will not be pre-planned. Spontaneously, due to the anger, this would have taken place. So, at the maximum, the lawyer's duty is to safeguard or to get a lesser punishment.
Right.
You can ask some questions to ensure that instead of 10 years imprisonment, ensure that he is sent to a life prison. Yes. So these are things which I wanted to.
They are very practical things, but
Practical things we
can
know.
learn only by practice.
Yes.
Item number 1.
Lordship, this is a service matter with regard to an assisted teacher.
Teacher. Dismissal.
Your Lordship, termination.
On the ground of?
Ground, Your Lordship, what I have a seal here is because the termination was done without the prior approval of the competent authority.
No prior approval.
No prior approval. And secondly, Your Lordship, there was no inquiry.
No inquiry. No
inquiries.
So for the state is
supporting my case.
So for the state is concerned, Your Lordship, we have.
Who is opposing you?
And for the
Managing committee.
respondent number 5, Your Lordship, I will give my submission after finishing.
Well, all of you are ready?
Yes,
Lordship.
Ready?
Ready.
Shall we have it in the afternoon? Or some other day?
Some other day.
Some other day, Lordship.
Any day, Your Lordship, I am ready, Your Lordship.
I am also ready. Morning. How many cases are there? 2 more.
Yeah, correct.
So today is coming up.
Come
No?
up any other date also, Your Lordship.
So we'll take it up next week.
Right.
Next week. Most next weeks.
Lordship.
Oblige.
Deputy oblige.
Oblige.
All the 3 cases we'll take it up next week.
Lordship.
He wanted to mention. Yes, sir. Item number 3.
Well, 2 and 3, my lord.
Yes.
It's a connected matter, Your Lordship. And in fact,
Item number 2 and 3, my lord.
before my learned semester,
1, 2, and 3 are connected, or 2 and 3 are connected.
2 and 3. 2 and 3, Your Lordship. Your Lordship, if this matter may be taken up after 10 days, because I'm not fully prepared today, Your Lordship, to be honest.
The request of so and so pose a matter after 10 days. The specific date. Madam, ensure that cases are spread over. Some days, we get only 3 cases. Some days we get 20 cases. Yes.